everybody. Starting the City of Brunswick Planning Board meeting for December 9th, 2019. We can take a roll call.
Felix Acheka.
Here.
Dale Vickers.
Here.
George Shadid.
Here.
Christelle Tella. John Petrolino.
Here.
Ryan Berger.
Here.
Suzanne Sikora Ludwig. Bob Cardica.
Here.
Manuel Castaneda.
Here.
Jeff Crum.
With the public announcement.
Please be advised that the notice requirements of the Open Public Meetings Act have been complied with and satisfied, and the annual notice, which gives sufficient notice of the time, place, and conduct of all public meetings of the Planning Board of the City of New Brunswick, has been filed with the City Clerk and placed on an appropriate bulletin board in the lobby of City Hall, 78 Bayard Street, in Brunswick, New Jersey, and has been transmitted to the official newspaper of the City of New Brunswick, namely the Home News Tribune and Star Ledger.
So we can all
Allegiance to the flag of the United States of America, and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
take a moment to review the minutes from November 18th meeting. Asking if there's any edits or any issues. And if not, if I can get a motion to approve.
I'll move. Second.
Okay, Felix Acheka?
Yes.
Wait, actually, only the people who were present, right?
That's correct.
Okay. Wait, Felix was on there, Felix Acheka, yes. Suzanne, Chris, Ryan?
Yes.
Berger? Yes. Bob Cardica?
Yes.
Manny Castaneda?
Yes.
Okay.
Great. Moving to resolutions of memorialization. First one, Cal Associates LLP PB-2019-07, site plan and variance applications for installation of signage related to the existing industrial Aaron and Company plumbing supply business and installation of two refuse enclosures located at 10 Industrial Drive, block 597.01, lot 9.01. What we got?
Motion to approve.
Is that what we need? All right, that works.
Motion second, and those who voted in favor of the application. As a
It's
general,
only the
on
last
this one, I do have a conflict, so I can't provide advice about the specifics of the resolution of approval.
Right.
So if there are questions, then we have to postpone the memorialization. But as a general rule, the only people that can vote,
Other
make
people
a motion and second are those that participated and approved.
So those would be
Yeah.
the same people who voted on the minutes as well.
Okay.
Okay.
Yeah.
If you want to take a minute to look if there's any questions. And then for those of you who weren't here on the 18th, and then if there's issues, then we can discuss and table if need be. And if not, then I'll ask for a motion to approve by those who were here.
I'll move. Second.
Okay. Felix Acheka?
Yes.
Ryan Berger?
Yes.
Bob Cardica?
Yes.
Manny Castaneda?
Yes.
Okay.
Okay, moving on. City of New Brunswick Municipal Public Access Plan. Adoption of Municipal Public Access Plan as an official component of the Parks, Recreation, and Open Space element of the master plan. This follows the same suit as the previous one, right? We're talking about,
Correct. There's only one correction to the resolution of approval. On the last page, it refers to this as a master plan re-examination. The word re-examination needs to be deleted. I apologize.
Is that just strike it and still, we can
Yeah,
still
the
adopt it?
Yeah, it hasn't been adopted yet, so I would strike it in the final version.
Okay.
okay. Yes.
Can we ask any questions?
Yes, absolutely.
I thought it was just kind of odd that there was no date on the plan that was reviewed. Then took a look at the plan and realized there was no date on the plan. It just said final draft, which I thought was kind of. So it must have been about 20 drafts of that plan.
I believe that the draft itself was from some 6 years ago.
No, it's 2017, I think.
2017.
I think that was
And
final.
when we finalize it, I'm going to edit it to remove the draft and everything. So when you were looking at it, it still said draft, but we're gonna take that out before we post it on the website and circulate it. So, yeah.
Yeah, I vaguely recall it being October or November of 2017 when it was
So
finalized.
the body of that recommendation itself is unchanged. The only thing that would be changed is obviously the notation of the draft.
Okay. Yeah, it just said final draft on it. There was no date, no nothing else on there. I don't know, thought that was a little strange. So I'm just saying.
Yeah, we'll date it and put the,
Okay.
remove the draft.
Okay.
Sure.
Okay.
Can I get a motion?
Same four people.
Motion?
Billy Tcheka,
Yes.
Brian Berger,
Yes.
Bob Cardigan,
Yes.
Manny Castaneda.
Yes.
Okay.
Moving on, public hearings, so adoption of the 2020 planning board meeting schedule. You all have a copy of this, if you want to take a look at it, see if there's any particular issue. This follows the same suit as the.
Right, so the real question, given discussions that we've had throughout the year, is whether or not you want to change the time to 7 PM to be in line with the zoning board going forward next year. That's, or if you have any issues with any of the dates here, they are all typically the second Monday of the month, with the exception of October 5th, which is the first Monday because of the Columbus Day, and everything else seems to be in line with that same trend. So unless you have any conflict with that, or with this, you want it to start at 7 o'clock or a different time, I would leave it to the board to have this discussion.
I know that there's been discussion in the past about moving the time to 7 o'clock, so we can have that discussion if we want to be fair to the ones who are not here, and maybe, is there a possibility or not? No, don't care. You're not here? Oh, well. I'll leave it up to the, well, let's see, are there people that want to move it to 7 o'clock? I don't know, I do. Okay, can I get a motion then? It would be a
Well,
motion,
I mean-
or is it a matter of discussion? Is there anybody
It's a
against
discussion,
that?
it's good.
Anybody against a 7 o'clock start, that want to maintain the 7:30 start?
No one wants to move to 8? Everyone can vote on this one.
Yeah, so can I get a motion? For, I think we have to stick with these dates, correct?
Correct.
Before you go to that, there's, the rules that we adopted some years ago indicate that there would be no new testimony taken after 10:30. I would imagine that even though we're starting half an hour earlier, just in case the schedule is busy, that you would still maintain that no new testimony taken after 7:30, I'm sorry, 10:30, unless the board decides that it wants to extend the hours past 10:30.
Would we have to make a rule change in order to push that back to 10?
No, it would just be a consensus of the board on that evening if we went past 10:30.
Right, so right now it stops at 10:30, so even if we move the start time up half an hour, we're still bound to go until 10:30?
Correct.
Unless we do a formal rule change.
Correct. I don't get a vote in this, but obviously I would recommend that you keep it at 10:30. It gives the board more flexibility. It also puts the applicants on notice at least, so they can either abbreviate or for their scheduling purposes, they know they've got to maybe wrap things up sooner or carry it to another date.
Okay.
Just mention that I do, when we first, this was first brought up a few meetings ago, someone did say, I can't do that. I'm not even sure who that was.
If I recall correctly, I think it was Suzanne. I think she has a conflict every other month that would preclude her from getting here before 7:30. It's been months since we had this discussion, so I can't speak to the accuracy of that, but I recall that pretty strongly as being the issue.
I mean, I kind of bring up what I brought up earlier was, do we wait on these give people the opportunity, or do we feel that with sufficient majority, we just pass at 7 o'clock? mean, in theory, there's nothing stopping somebody from motioning and then if it's seconded, it's a vote.
Yeah, I would move for something like that. Seems like it works for everybody else. So I've got alternates and a full complement of willing people, so.
And if need be, it could be, not that we would want to relitigate this next month, but when we do reorganization, it could be brought up again and rediscussed with everyone presenting their side if they're here. So I don't see an issue with it.
All right, can I get a motion then?
So I'll move to adopt the calendar as presented with one amendment to change the start time to 7 p.m.
I was like, you've accepted this.
Okay, Yulitza Checkham,
Yes.
Gail Vickers,
Yes.
George Shadid,
Yes.
John Petrolino, Brian Berger,
Yes.
Bob Cardica,
Yes.
Manny Castaneda.
Yes.
All right.
All right, moving down the road. Amendments to Title 17 zoning ordinance, planning board review of proposed amendments to the city zoning ordinance relating to electrical vehicle parking, bike parking, and rebuilding on undersized lots.
Okay. Mr. Chair, or Vice Chair, so I will go through these amendment proposals that we had referred by the city council last Wednesday, one by one. First, we'll start with the electric vehicle parking. This was somewhat inspired by some of our neighboring towns that have begun to enact their own electric vehicle parking requirements in the future developments. These include Piscataway and East Brunswick and possibly some more, but offhand I remember those in particular. So our setting here would be on non-residential projects and on residential projects of 10 or more units would be the only ones compelled to comply with this, although they could, of course, if they have their own justification, present as to why they could get a variance or need a variance from the requirements, but otherwise would have to meet these requirements. Non-residential, aka a shopping center or the like, would have to provide one charging space for every 25 spaces provided, or 4 per 100. Residential with 10 or more units will either have to provide 3% of its spaces as a level 2 charger, or at 5% as a level 1 charger, which is a lower standard with a minimum of 1 space. So a 5% of 10 units is half of 1 parking space, so they would have to meet the requirement of still just having at least 1. For non-residential purposes, to encourage the adoption of electric vehicle charging stations by private development, we would allow electric vehicle charging parking spaces to count as 1.5 spaces for zoning purposes, but only for non-residential, because in residential we are preempted by the state's RSIS standards, which the board can grant variance relief from, but we can't codify into law something in conflict with the RSIS standards. So we can't give them that relief in ordinance form. But the board could feel free to do so on a case-by-case basis if they felt that that was a sufficient offset for any group that came here presenting any applicant. But we would codify it for non-residential. Then for the second set of changes, we would be requiring bicycle parking. We try to push developers to do this anyway when they have several units. On a lot of the 40+ unit buildings, we push for bike racks inside of parking facilities. This would just codify it rather than it being an ask. We would codify one bicycle parking loop, as the loops you see at any of the other parking racks, for every 2,000 square feet of general floor area, with a minimum of 2, and then residential of 10 or more units would have to provide at least 1 similar parking loop for every 10 units with a minimum of 3. Again, this is exempting small-time development. Your single and 2 families won't be obligated to have electric vehicle parking or bike parking, so this is only really at scale here. And then finally, in the zoning ordinance, there exists a language that was, it sort of has survived several iterations of the zoning ordinance and has caused a lot of confusion. If you read into it deeply, it essentially says that if you have a lot, a parcel, that was developed before 1972, and either A, it is now destroyed, let's say there was a fire yesterday and you want to rebuild, there are certain parameters in the code that allow you to say, sure, you don't have to come for a variance. If it meets all these parameters, you can just go get a regular zoning permit and rebuild to the specs that you had, as long as this is okay. Additionally, what the existing code says is that if the building existed in 1972, it was burned down in 1973, it's currently an empty lot, there's no foundation, you could rebuild to those specs as per the tax records that we have, and without a variance, as long as it meets those pretty generous criteria that already exist in the zoning code. However, throughout this year, I've had a lot of applicants come through saying, oh, well, because, all right, so for one example, the FAR for those rebuilds is 0.8. For all of our R5A district, which is a significant portion of New Brunswick, that single and two families are allowed in, our current zoning code is 0.35. So you get a lot of applicants who come to me and say, well, why can't I add a whole floor onto my building? This says 0.8. It doesn't work that way. But the language is sufficiently clunky enough in the existing ordinance, because it's existed for so long, that you get people who get pushy and try to make things complicated and make that argument. So what this would do is basically just clarify the language to make it explicit that the limitations are for those rebuilds, and not that you can just use either this parameters of zoning or these parameters of zoning, depending on how you feel or what works for you. This is not applicable for improvements to your property. These are only applicable for rebuilds. So that's what that would do. And those are the 3 points of amendment to the zoning ordinance that the city seeks and has presented to you for advice and consent.
Question.
Absolutely. Fire away.
So on the clarifying language, there's no change involved.
In terms of the parameters?
Yes.
No, absolutely not.
You're just making it more explicit.
Correct.
So that you have to deal with less challenges.
Correct. Then no one can read it in the future and say, this applies to me putting an addition on my house. That's all.
Okay.
Yeah.
So in that sense, we don't need to see the language. It's just that you're just going to clarify it.
Exactly, yes. No changes to any of the specs in there, just explicit clarification that it's for rebuilds.
Just as a point of order,
Yes.
well, clarification on the clarification. We don't write the zoning ordinance. The governing body writes and adopts the zoning ordinance. They ask for our advice, because this is the planning board has the expertise. And so what happens is that the governing body sends over the request with the proposed changes that they're looking for, the general parameters perhaps. And the planning board can make a decision, have a discussion, dialogue about those general changes, and send back the recommendations to the governing body. And the governing body will adopt an ordinance based on either your recommendations or can disregard it, but we have 45 days from the referral from the governing body to act and send them back our recommendation. Again, we don't enact ordinances in the planning board, so it's only the recommendations of the planning board which has subject matter expertise in these matters.
We recommend that you go ahead and clarify the language, essentially,
Yes,
to
sure.
the zoning.
It's to the governing body.
To the city council.
Dan, I have a question. With respect
Yes,
to,
ma'am.
you said with the bicycle and I'm assuming also the electric spaces, that they were recommendations at one point, or that they're currently recommendations that are provided.
Well, not so much the electric vehicles, that's still,
Relatively
to
new,
call it cutting edge is maybe a little bit hyperbolic, but yeah, it's a little, not so much. But parking requirements, every single project that you've seen in the last few years that has had a bike rack, you can ask Mr. Ital, that's Glenn pushing for it in TAC or in other meetings. This would just make it codified so that it's less of a pushback.
So
And
this is the same as what the recommendation was. So it's just a matter of changing it from recommendation to required.
More or less.
Right, so that if they couldn't meet the requirement, because they could, and for lack of a better way to put it, they could just tell us to pound sand.
Right.
But they're not gonna put it in. There's no legal requirement, and we can't say, well, we're gonna deny your application. It's perfectly conforming in all other respects, except you're not taking our, strong hint that we need bike racks.
Right.
So by codifying it, they know from the initial application process that there's this requirement that they also provide bicycle racks or electric vehicle parking. And so if they can't meet that, then they have to come to this board or to the zoning board if there's a use variance or another D variance that's required, and ask for the relief from the standards of the zoning ordinance. So, essentially we're making it law.
Right, okay.
Additionally, some of the more recent redevelopment plans, like the Farron lot, that has some bike rack codification in there as well. And I would argue that this was sort of inspired from reading that redevelopment plan. So I think that going forward, it's something that we would like to see codified to just make this easier rather than ever a fight. It's just, these are the numbers, meet them or don't meet them, but if you don't, now present as to why you can.
Great, thank you. Any more questions from the board?
And one more, on the EV.
Yes.
Requirements. Are there, since these would be requirements rather than just, recommendations.
Right.
Are there any state or federal incentives to these folks? Do they able to get any grants to assist with this kind of thing? Just wondering.
That's for them to find. I don't know. I think the state of New Jersey still has some stuff. I think the federal grants are, well, that's for the cars are phasing out. I don't know if there are any charging grants from the federal government, but I do
No, but
believe
if
that
they
there are some.
Put up solar panels to charge it, there's still some grants that are available.
I do believe that the cities, the parking authorities' parking decks, many of them have chargers in them.
Yeah, see.
And I believe that based on the discussion that we had at Traffic Commission last week, I believe, was it last week yet? That they did get some grant funding for the ones that they installed in those facilities, but I'm not sure if that grant funding opportunities are still available.
Yeah, it's a valid point. That's cost to development of the property.
Right.
I don't know how much it costs, but it's not free.
And just want to clarify, I misspoke. The solar panels, it's not a grant, it's actually tax incentive.
Just a point of clarification, Dan. So saying that the parking spaces, each EV space counts for 1.5, there's no maximum on spaces, right? So that will not be seen as a detriment, inhibiting the number of desired spaces. Is that
No,
correct?
correct.
Okay. Just making sure.
Any more comments from the board? Open it up to public comment. Stay quiet, Charlie. All right. Hearing none, can I get a motion?
Motion to recommend the proposal, the amendments to Title VII zoning ordinance as drafted.
Can I get a second? Second.
Doesn't have to be roll call.
So just,
Yeah. Voice vote will do it.
So all those in favor?
Aye.
You're going to have to ask for opposed. Any opposed?
Oh, sorry, any opposed? Okay, so,
That's our agenda, sir.
all right. Any other matters of interest to the public?
Good evening, members of the board. Charles Craddock, New Brunswick Today. Following up on
Yeah,
that.
this way.
Oh, sure.
State your name, spell your last name.
Charles Craddock, K-R-A-T-O-D-I-Y.
You swear or affirm to tell the whole truth and nothing but the truth?
Yes, sir. So I'm here to follow up on an issue I've raised a couple times now about the state's largest healthcare system, RWJ Barnabas, violating the French Prospect redevelopment plan parameters. Wanted to ask what's the status?
Please.
We've finally got review through the redevelopment plans and the resolutions. We feel like we have our ducks in a row, so to speak, and we're ready to approach the people that we need to with all of our stuff in line. And hopefully we'll have a resolution to this in the next 30 to 45 days, I would hope.
Okay, and so just to be clear, we're in agreement that they are out of compliance, may never have been in compliance, and that they are required to operate an interior walkway for the public.
You and I may have some disagreements into some of the parameters of that, but the general gist is that yes, we've spoken briefly about this. But the general gist is that yes, we are in agreement that there is some violation of the agreement that the developer agreed to. The current owner is still bound by those, although I believe it is different than the developer that created the site, and is different than the developer that's working on the other site of the redevelopment area. But yeah, so our intent is to get them to correct it within the parameters of the resolutions and the redevelopment plan, and have it corrected ASAP.
Okay, and by what process will that happen? Is there going to be is it in writing? I would imagine if any of us had a zoning violation at our home, we'd probably get written, notice at some point and say you have X number of days to correct it, or else you're going to be in trouble. Is there a letter going to be sent? Has one been sent?
A letter has not been sent. I don't know if that's the tactic that we're going to take. We're still going to shop that around internally, but we're going to work on sorting this out. That much I can say.
Okay, because again, just in case you don't remember, I did bring this up to Robert Wood at their board, so their CEO is aware of it. Said he would have to look into it, but have not.
We're going to bring the parameters to them so that they're very clear in black and white, and they will then know what they need to correct.
Okay, well, fair enough. I appreciate you taking the time to look into this, and I would just ask, if you possibly could copy me on the communication or send me just a PDF copy of it when it does go out, if and when a letter goes out.
If a letter goes out, we'll copy you on it.
Okay, I appreciate it. Just want to wish everybody a happy holiday, and thanks for your time.
Any other matters of interest to the public? Hearing none, any discussion items? Hearing none. Before we adjourn, I'd also like to wish everybody happy holidays. Stay warm and be merry. Have a good one.
Did you would say that?
Motion to adjourn.
Motion